Yeah, thanks, Minister. I'm happy to withdraw our amendments on that basis. I think your own Amendment 1 is actually what we, in fairness, what we were looking for. And I know that there was a lot of kind of discussions back and forth. And in general, I thought even from kind of the original stage to second stage, there had been a lot of I don't know if improvements is the right word, but there have been a lot of changes that I think were really good and really significant. So we didn't have sort of a huge amount of amendments from our point of view anyway, but I'm happy that your Amendment 1 deals with it, and I'm glad that that was taken on board, and I think it's important, and I'll leave it at that. Thanks, Cathleen.
Amendment number 1, the Minister, has already been moved. Is it agreed that Amendment number 1 be made? Agreed. Amendment number 2 is in the name of Deputies Funchion and Ward and is withdrawn. Amendment 3 is in the name of the Minister. It arises out of committee proceedings. 3, 47 and 54 are related and can be taken together. Minister, will you move number 3?
I move number 3. Okay. Deputies will be aware that I significantly expanded the list of family members who can participate in the DNA identification programme from that set out in the original general scheme, and the published bill took full account of the PLS recommendations and provided for participation by a child, parent, sibling, half-sibling, grandparent, grandchild, aunt, uncle, niece or nephew of a person who's buried in the intervention site. I indicated at committee stage, and it was in response to an amendment proposed by Deputy Canny, and I don't think we weren't able to discuss it on the day, but I did indicate at committee stage that I'd look at what you and Deputy Tobin had brought forward, and it's on foot of that I'm bringing forward Amendment 3 to consider expanding the range of relatives that can participate in the DNA identification programme to include grandnieces and grandnephews, and Amendments 3, 47 and 54, the set of amendments I'm speaking to, provide for the expansion of eligible family members to include half-nieces, half-nephews, grandnieces and grandnephews. So we engaged with Forensic Science Ireland, and all our decisions in terms of what members of family can participate in the DNA programme is very much based on the scientific ability to get usable samples of DNA, and of course as the relationship decreases, as it spreads out, the amount of usable DNA is going to decrease. So it's solely on that basis that we've made calls here. So when you're getting to maybe, 50%, 25%, 12.5%, it splits going each time. But we have engaged with Forensic Science Ireland, and they said there is a scientific justification for the inclusion of half-nieces and half-nephews, as well as grandnieces and grandnephews. The technology that Forensic Science Ireland will invest in to detect second-order relatives is also capable of identifying this group of relatives, so I believe it is prudent to expand the list of family members in line with the scientific advice. So I hope, again, we will be seen to have been taking on board the positions made by deputies. I think in your original amendment you had cousins included as well. That is a different situation because you're coming down a different line of the family, so the amount of DNA is immediately lower than you have with direct family representatives, and we were told by Forensic Science Ireland that the amount in terms of cousins would probably be too small to undertake a successful DNA analysis. But on foot of your amendment, we are expanding it out, as I say, to include half-nieces and half-nephews and grandnieces and grandnephews.
Yeah, just briefly on this, so the change, I just wanted to ask a clarification. The change is half-blood. That wasn't in it before. Am I correct in that, saying, Minister, that it was just, it didn't actually have that part? Okay, I wanted to ask that. I welcome this. I think it's good. I think it is a positive step forward, and I'm wondering, I do see where Deputy Cannon is coming from as well, and I'm wondering, is there a way of, maybe even in the guidelines or in the, not necessarily in the legislation, but is there a way of maybe covering some of that for even like in the future? Obviously science is something that's always evolving and changing and advancing, so could it be somehow make some sort of reference to it in the guidelines, even if it can be put in the actual legislation? But I do think that it's good that it has been expanded, and I kind of see both sides of the argument, because I do know they say with science, as you kind of go further down the chain as such, you've a less chance of knowing the relationship. But then when you know people who are directly involved and are looking to see if they can be kind of traced, it's very difficult. So I don't know if something in the guidelines afterwards could be a potential solution. Thanks.
Thanks. So just to clarify, so it used to be niece and nephew, and it stopped there. So now it also includes niece and nephew. Clarify if it's half blood or full blood as well, because the percentages will still be the same. And it also clarifies that grandniece or grandnephew, that category wasn't included before, and it is included now. Look, I take on board what you're saying, Deputy Canny, and I understand there are people who are, I suppose, let's say at the relationship of cousins from a potential child who is buried in, for example, the tomb site, who are deeply concerned and want this ability. I'm not going to be able to make a legislative change on it today. What I will say is, I suppose, there will be an implementation group set up in terms of overseeing the application of this Act. And as you know, we'll also be reviewing this Act. So I think there is an opportunity then. And I think particularly if we've seen that advance in science in terms of maybe making a change at that stage, there's an opportunity. And of course, people can get their own DNA taken and a process undertaken to preserve that as well. And, you know, you can give DNA at any point in your life. But I suppose the key concern for me right now is that, and this is not me saying, it's the experts saying that there is not a capacity to, I suppose, with the degree of certainty we'd need, link a person who's at a cousin's removed from a child who was buried in this site with the degree of accuracy. And I suppose I do have to take that guidance where I've seen there has been some where I've seen it could be widened to usable effect. I have done that.
Thank you, Minister. Is Amendment 3 then in the name of the Minister agreed? Agreed. Thank you very much. Amendment number 4, 33 to 39 inclusive, 55 and 56 and 62 to 64 inclusive are related and will be discussed together. However, Minister, it'll be necessary here to seek a recommittal in respect of this group because it relates to the instruction to committee motion that we've dealt with. So, Minister, can you firstly move for a recommittal?
I move.
Is that agreed? That's agreed. Do you want to move Amendment 4 then?
Yes, I move Amendment 4, and I'll speak to all the amendments that you listed there. So at committee stage, I signalled my intention to bring forward new provisions at report stage to provide a legislative basis for an oversight committee to perform an assurance role in respect of historic databases established under the bill. And given the sensitive data to be processed and the risks associated with any potential breach, it is prudent to provide for a specific oversight structure with reference to the DNA analysis that will be carried out under this Act. And I believe that these new provisions will strengthen the legislation and its operation. Amendments 4, 55, 56, 63 and 64 make provisions for an oversight committee to perform this assurance role. The DNA Database System Oversight Committee was established under the Criminal Justice, Forensic Evidence and DNA Database System Act of 2014, and the amendments provided here that where the function of a director include carrying out the identification programme, and where that programme is continuing, the relevant minister will, with the prior consent of the Minister for Justice, direct the Oversight Committee to oversee the management and operation of the databases established under this Act for the purposes of maintaining the integrity and the security of the database. So, I suppose maybe just to simplify, there is an existing structure put in place for the monitoring of DNA databases, recognising the hugely sensitive nature of that information, and we're looking to ensure that the databases for DNA that will be constructed in terms of seeking to link relatives to children or remains found in these sites, we're looking to ensure that those databases will be overseen in the context of the existing structures and structures that are working and that are operating well. And we've had very significant engagement with the chairperson of the existing DNA Database Oversight Committee. So where the committee is performing its function, it will meet as the Historic Remains Databases Oversight Committee. The amendments recognise that this is a distinct and temporary function which is best managed in a distinct and standalone way by the committee. They set out the functions of the committee in this regard, as well as the arrangements for remuneration, expenses and secretarial support. The committee can review any matter related to the operation of the DNA databases and prepare a report on the review, which will be laid before the Houses of the Oireachtas and published. The committee will prepare a final report within 6 months of the conclusion of the identification programme and provide a copy to the relevant Minister, the Minister for Justice and the Director. The relevant Minister must then lay the report before the Oireachtas and publish it. Amendments 37 and 39 are consequential amendments regarding the disclosure of confidential information. The amendments specify that members of the Oversight Committee, as well as contractors, consultants or advisors the committee has engaged, cannot disclose confidential information at any time unless required or permitted by law or duly authorised in writing to do so by the Oversight Committee. Amendments 33 and 36 clarify that confidential information obtained by a specified person or members of staff of FSI shall not be disclosed at any time, and not just while performing functions under the Act, unless such disclosure is required or permitted by law or authorised in writing by a Director or the Director for FSI. These technical amendments reflect the wording used in Amendment 37 in relation to disclosure of confidential information by members of the Oversight Committee. Amendment 73 is a further consequential amendment that provides for the Oversight Committee's functions to be performed by a suitably qualified person in situations where regulations are made to allow for further forensic testing in circumstances where there are developments in forensic testing after identification programme is completed and the office of a director is dissolved.
The amendment in the name of the Minister, is it agreed? Amendment 4 is agreed. Amendment 5 arises out of committee proceedings. 5, 10 and 46 are related and will be taken together. Minister, to move number 5.
Mr Chairman, Court is speaking to amendments 5, 10 and 46. This set of amendments is being brought in response to amendments proposed by Deputy Carnes at committee stage, which sought to delete the word ordinarily from the phrase ordinarily resident at the institution in the context of defining principal burial land. I understood the Deputy proposed the amendment as she was concerned that the term ordinarily could restrict the people whose remains would be covered by the legislation by implying that an individual was resident for a prolonged period of time. I clarified the intention that ordinarily resident would include a person who was resident for even one night in an institution, but indicated that the necessity of the term could be considered. So we engaged with the Office of OPC. The Office indicated that ordinarily wasn't necessary. So hopefully in terms of providing further reassurance and again, and having it on the record, by subsequent to this amendment, it will still be someone, if they were a resident for one night in one of these institutions, they will be covered. It was the case previously, but just in order to provide reassurance, we're deleting the term ordinarily in those 3 locations.
Number 5 in the name of the Deputy Funchion.
Welcome that, because I remember that discussion at PLS, and sometimes, particularly when you're sitting on this side, it seems like, you know, it's so easy or so simple to make 1 or 2 small changes that are really significant, and I think that was one of those areas, and I think it's really welcome, and I'm glad that that amendment has been made, so thanks.
Whitmore.
I'm going to speak to Amendment 45 because it's in this group in 2. I'm correct in that, am I? Yes. Yeah, okay, perfect. Okay, so R1, it's sorry, is it? Yes, it is. Okay, perfect, yeah. So just briefly, our Amendment 45 is in page 35, line 8, after violent, insert accidental, homicide, undetermined or suspicious deaths. And this amendment seeks to just expand the criteria in this section in which An Garda Síochána is alerted to evidence of human remains. We believe that there's a real possibility that some deaths may not be adequately examined if such a death was to occur now. So it's just to really strengthen that particular section that we're proposing that amendment. Thank you.
Thanks, Deputies. And I note that the amendments similar to Amendments 6, 11 and 45 were put forward and we discussed in committee stage. And for the reasons I outlined then, I'm not in a position to accept them at this point. The purpose of this legislation is to provide for the excavation, recovery, analysis, identification and dignified reinterment of human remains buried in a manifestly inappropriate manner. And this is the legislative gap that this bill is seeking to address, so an intervention can take place initially at Tuam and subsequently at any other sites should a similar set of circumstances come to light. Amendments 6 and 11 seek to alter the definition of principal burial land and the conditions for making a government order so that an intervention can take place, which does not relate to burials that are inappropriate, but rather relates to burials of persons whose deaths may have occurred in a violent or unnatural manner or sudden and unknown causes. As I outlined previously, this approach would fundamentally alter the scope of the bill and ultimately change the underlying objective of the legislation. And I have to say, I disagree with you, Deputy Whitmore. I do believe that these amendments would represent a strong interference with the jurisdiction of both An Garda Síochána and the coroner. And I took significant action when I brought this bill back after the PLS to make sure the jurisdiction of the coroner was maintained, and that was something that was had been asked of the government through the PLS process and directly of me by survivors that I met, and we were able to secure that. Any intervention and investigation in relation to violent or unnatural deaths should come clearly under the remit of those two bodies. And that's why the bill rightly provides upfront that an order may not be possible if an investigation or inquest is already underway and the Garda Commissioner is of the view that it would be premature to make an order for intervention pending the outcome of that investigation. And similarly, the bill rightly provides that where an intervention under this legislation is underway, a director must notify An Garda Síochána and the coroner of any evidence of violent or unnatural death which comes to light during the interventions and then follow their directions. And moreover, it's unclear how, within this specific legislation, it would be established prior to an intervention that a death occurred in a violent, unnatural or sudden and unknown manner. And this legislation seeks to complement existing law, including the Coroner's Act, not to replace it. And as a major change to the general scheme, as I said, I removed those restrictions on the jurisdiction of the coroner. And furthermore, under the legislation, the director will have to try to identify the circumstances and causes of death of recovered remains, and if evidence of violent or unnatural death emerges, notify the coroner, notify An Garda Síochána immediately. In relation to Deputy Funchion's Amendment 45, it's related to changing the description of the type of death that must be notified to the coroner and a member of An Garda Síochána. And as I had outlined at committee stage, the current wording of violent or unnatural would cover any suspicious death where there is potential evidence of same, including homicide. It's also necessary to keep the wording aligned with the basis for exhumation in the Coroner's Act. More broadly, the Director will publish the full post-recovery analysis report in respect of all recovered remains, which will include the cause and circumstances of death where it's possible to identify this. The Director will ensure that it is brought to the attention of the relevant coroner, and in addition, Amendments 42 and 44, which were discussed under Grouping 1, will ensure that the post-recovery analysis report will document whether notifications of evidence of violent or unnatural death have been made to An Garda Síochána and the coroner, and it's for those reasons I'm not in the position to support these amendments.
Deputy Funchion to move Amendment 12 and to address 12 and 13.
I'm actually withdrawing Amendment 12.
You withdraw.
Yeah.
Okay. And 13 is with 13 is in the name of the Minister. Are you pressing 13, Minister?
I am.
Is Amendment 13 agreed?
Might I speak to it briefly?
Well, yeah, if you want to.
Just very briefly, just to recognise that the issue that's been addressed here in terms of how close to a residential house on land can an excavation take place was one we debated significantly in the original PLS. Having a residential house entirely excluded it in the bill as brought forward. We'd brought that to 20 metres. Concerns were raised by yourself and by Deputy Kearns, so we've brought that to 10 metres within the curtilage of the house. So I think that strikes a fair balance. And thanks to deputies for their input on this.
So that's Amendment 13. Is Amendment 13 agreed? Agreed. Amendment number 14 in the names of deputies Funchion and Ward, is that agreed? Or is that withdrawn?
It's not withdrawn, but
Okay.
I'm happy if people want to agree it, but I don't know is it going to be that easy.
Okay, amendment 14.
So 14, is this on its own, is it?
No, 14 to 16 inclusive are related, so maybe you'd move 14 and
Okay.
you'd address the three of them.
I move 14. So this one is in page 15 at line 24 to delete section 5 and supplement with the following. The government shall make every effort where a site proves problematic to resolve difficulties and thoroughly examine burials on the land before it is determined that memorialisation of the burials on the land is more appropriate. So the reason for this amendment is that a memorialisation in the absence of excavation, exhumation and identification of remains to a certain extent can contradict transitional justice or the idea of transitional justice. It is impossible to memorialise something if we do not know or agree on what we are acknowledging. The report of the expert technical group itself states in order to memorialise it is essential to know what and whom are being acknowledged. Further investigation on behalf of government would be required in order to memorialise effectively. In the absence of specifying what the substantive reasons are for not engaging an intervention, it is impossible for this provision to be proportionate engagement with the rights and preferences of victim survivors, including former residents of institutions and their families. And also to note Ireland's international obligations under relevant EU and UN conventions, just in relation to memorialisation measures in lieu of a proper investigation, as suggested, would appear to allow any Irish government, just to kind of go with memorialisation basically over an actual investigation. And I know, as I'm saying this, that's not going to be the case in every situation, but it's just to avoid that. And I suppose if you just actually look at the wording of the amendment, it's to basically say that the government shall make every effort where a site proves problematic to resolve difficulties and thoroughly examine burials on the land. I suppose it's just to make sure that absolutely everything is being covered. That's the reasoning for Amendment 14, or behind why we've submitted Amendment 14. 15 and 16 then are linked and have kind of the same rationale. So there's no reason to restrict the functions of the Director. It seems unnecessary and could foreseeably impact effective investigation and potential digs at sites. So the Director should report to the Government the issue of such sites, but any decision not to proceed with the excavation of the suspiciously buried remains should lie at least with the coroner, the families of the unidentified individuals and the advisory group, where the views of the wider survivor community would also be taken into account. So that's the rationale for 15 and 16. Thanks, Ceann Comhairle.
And I have considered the PLS recommendations on this specific issue, and in light of these, the provision in the legislation has been amended to specify that the Government must have substantive reasons to form the view that memorialisation of the burials on the land without further intervention is the more appropriate route to go. So this provision is not designed to allow the Government to refrain from intervention. The Government will have to set out clearly the reasons for choosing memorialisation, and the rationale has to be sufficient and reference to some technical difficulties which would be such to adequately justify the decision not to make an order. In terms of Amendments 15 and 16, Section 7 specifies that the Government may establish the office for a specific period in order to allow it to intervene at a site associated with an institution which contains manifestly inappropriate burials, in order to help ensure the officer's effective operation and to adjust to the evolving situation at a particular site. The relevant minister may need to alter the functions of the Director, and as such those proposals would need to be approved by Government. I would like to reiterate that the provision is not designed to prevent the Director from undertaking a certain activity. In fact, any such proposal is based on information provided by the Director, him or herself, which must be taken into account by the Minister. And the provision in effect allows for adapting the work of the office in line with the request from the Director. And this in turn reflects the reality that at the outset of an intervention there is likely to be a high degree of uncertainty as to what the Director and their office will encounter. If the provisions were removed as suggested, the Director may be legally required to perform a function that cannot in reality be implemented. For example, it is possible that the function of an identification programme is assigned to the Director at the outset, but if there were no living relatives willing to come forward to participate in that programme wouldn't have any function. And in this case, an identification programme might no longer be feasible, but if we hadn't the capacity to amend the range of functions that the director could take place, the director would still be legally obliged to undertake the DNA identification programme, even if it was no longer practically feasible to do.
Thank you, Minister. Deputy Funchion, are you pressing Amendment 14?
Yeah, President.
Na teachtaí atá thaobh na tairsin aber is tá. Each should the Tana Gun aber is Neil. As Dolim could butcher and cash to believe the question is defeated. Question is defeated. Amendment 15, is it being pressed? 15 withdrawn and 16 withdrawn. Amendment 17 arises out of committee proceedings. It's in the names of Deputies Funchion and Ward. 17 and 18 are related and can be taken together. Deputy Funchion, will you move Amendment 17?
I move Cian Corda, and 17 and 18 are together. Is that what?
Yeah. 17 and 18.
Okay. So these amendments are linked, so the kind of rationale is the same. So I suppose the crux of what we're trying to get at is that there's no principled reason to specify that contemporary burial practices from the 40s, 50s and or other earlier or later should apply to any potential burial lands. So I suppose kind of an example of this would be in certain situations it was practice at times that babies, particularly if they hadn't been baptised at the time or had died in childbirth or were stillborn, were possibly kind of buried in a different situation than would be acceptable now. And we don't want any situation to arise whereby that those lands might be, or those burials might be seen as, well, they were acceptable for the time. I hope I'm kind of explaining that in the way I mean it, and not in any sort of disrespectful way to anyone that would have felt at the time that was appropriate. But what we're trying to do is ensure that if there is, I suppose, a suspicious situation, that it wouldn't be maybe not ignored, but that it wouldn't be sort of not discovered, I suppose, because somebody might say, look, well, that was appropriate at the time. So that obviously that wouldn't be appropriate. Nobody would kind of accept that now in the modern age as such, and that is why we want to put in these two amendments, basically. So at the time of such burial, and to delete, and for Amendment 18 would reasonably have been so considered at the time the burials took place. It's just to ensure that there isn't, I suppose, any grey areas in that situation. Thanks, Minister.
This group of amendments, Minister, if you would, please.
Thank you. Thanks, Cian Corda. Just maybe to just set out the full section, it's just useful kind of to understand the position here. So this is deciding on the issue of in manifestly inappropriate burials. So these are the matters referred to in section 73A2 are whether in relation to the burials concerned the human remains are A, are uncoffined, B, are burials in such a manner that would not have complied with the requirements at the time of such burial specified in the burial ground regulations. C, are buried in a way that would not reasonably considered to provide a dignified interment, or are buried collectively and in a manner or in a location which is repugnant to common decency and would reasonably have been so considered at the time the burials took place. So that's the I suppose the criteria under which that important determination of manifestly inappropriate are determined. So Amendment 17 seeks to remove the phrase "at the time of such burial" from subsection 8(1)(b) of the legislation, and therefore, and in doing so, it would undermine one of the criteria used to assess whether there were manifestly inappropriate burials at a burial site. And it's important that the assessment of burials relates to the time when such burials took place and the agreed custom, practice and requirements of that time. It is difficult to justify assessing burials with reference to requirements that were not applicable or perhaps did not exist at the time of such burials. And burial ground regulations have changed since 1922, which is the start of the period where this legislation is applicable. Amendment 18 aims to delete all words from and including and in line 12 down to and including place in line 13 from subsection 8(1)(d) of the legislation. One of the criteria that the government must try to assess before deciding whether a burial site associated with an institution has manifestly inappropriate burials is whether most people at the time of the burials would have found the burial at a site like Tuam acceptable. Without the phrase "would have been reasonably considered so at the time the burials took place, it is a lot more difficult to interpret what repugnant to common decency means. And I don't believe we should undermine the rigour of the legislation by reducing clarity on this important and sensitive criteria. And I think to do so would kind of undermine what we're seeking to achieve here. Everybody in this House agrees that the manner in which the remains of children were interred into the chambers at Tuam was not and is not acceptable, and this is patently clear. However, future situations cannot be ruled out where the interpretation of common decency is more specific to the time when burials took place, and the phrases that the deputies wish to have deleted support the clear interpretation of the respective criteria that define manifestly inappropriate burials.
Amendment being pressed. Na check the atar heaven at Harishkin Arbidis Tá. In a gun Arbidis Neil. Stolen Gul Butcher and Kesh. To believe the question is defeated. 18 is House stands 18. Na check the atar heaven at Harishkin Arbidis Tá. In a gun Arbidis Neil. Stolen Gul Butcher and Kesh. To believe the question is defeated. Amendment number 19, also in the name of Deputy Funchion and Ward, rises out of committee proceedings. Deputy Funchion, will you move Amendment 19 and address it, please?
Yeah, I move this amendment to Kieran Corda, which is on page 16 at line 19, to insert any reliable evidence from a third party with knowledge of the circumstance and location of the burials concerned. So the reason for this is just the amendment seeks to expand the list of people who can provide evidence that the Director will be obliged to take into consideration. That is pretty much it. Thanks.
Minister.
Thanks, Councillor. I'm not proposing to accept this amendment, but it's because I believe what the Deputy is seeking to achieve is already covered within the provisions of the bill itself. Section 8.2b requires that the government to have regard to available evidence, including, and this is the current text, any reliable and corroborated statement made by a person with knowledge of the circumstances and location of the burials concerned. Amendment 19 aims to create an additional requirement that the government would consider any reliable evidence of a third party with knowledge of the circumstances and location of the burials concerned. However, it is in fact already covered by Section 8.2b, which stipulates that the government must have regard to any reliable and corroborated statement made by a person with knowledge of the circumstances and location of the burials concerned. The reference to person includes third parties, and the requirement that such an individual provide a statement is not onerous in the circumstance. So I'd like to make it clear that I do agree with the importance of taking all reliable evidence into account, but I do believe that the current provision sufficiently provides for that.
Thank you. And just Deputy, 20 to 22 is inclusive and they're related. So just to confirm that with you. So yeah, the 20 to 22 are inclusive, Deputy.
Thanks, Chair. I'm going to speak to 21 and withdraw on 22. So just to say that. So 21 then is in page 16 at line 21 to 32 to delete all words from and including important in line 21 down to and including line 32 and substitute the following: significant burial sites. The government shall make every effort to thoroughly examine and make interventions using the full resources and powers of the Director. The reason again for this amendment seeks to expand the remit in which the Director can make an intervention at a burial site. The existing Section 3 places unnecessary restrictions on the Director and could preclude an effective investigation or excavation on specific sites. The provision could foreseeably impact the dig in Tuam and have the result that some and not all of the site is excavated. I'm actually just wondering, is this somewhat dealt with in the earlier amendment about the 10 metres versus the 20 metres potentially? I'm sorry, I know I'm not supposed to actually kind of ask that question, but I'm just wondering if I could get clarity on that. I can withdraw it, but
well, just,
maybe it isn't.
I'm confident that the public interest test there will in no way interfere with the proposal to intervene in Tuam.
Okay, thanks. Sorry, Chair. Yeah, that's it. Yeah.
Thank you, Deputy. Minister.
20 and 21 were put forward at committee stage, and I can't accept them for the reasons that I outlined at that stage. The government has to balance the need to intervene with the need to respect the long-standing tradition of the sanctity of burials, and it's important to recognise that the excavation and recovery of human remains is an extensive, complex and sensitive intervention, and safeguarding public interest is an important concept, and it's used in other domestic and European pieces of legislation, and it's necessary to set out a strong legal basis grounded in public interest to ensure that the impact of the proposed intervention on constitutional rights is limited and proportionate to the aims of this particular piece of legislation. And it's on that basis that the legislation requires consideration of safeguarding public interest and sets out a number of factors that the government will take into account when determining if an intervention is proportionate. These include the need to accord dignity to persons buried in the land, the need to respect the views of relatives of persons buried in the land, public health, the impact of the intervention and alternative options, if any, which may be available. It's difficult to disagree with the importance of according dignity to persons buried in the land, and public health is also an important factor to have regard to, given that public health considerations are one of the main reasons why laws about the exhumation of remains are strictly controlled. We cannot disregard the impact on the wider public, including local residents. Furthermore, I know we all agree with the need to consider the views of relatives of persons buried in the land. In some locations, and we've spoken about this earlier, relatives may not be supportive of excavation, and these views need to be respected. So again, but I would like to stress that nothing in this test, I'm confident that nothing in the test is set out there would in any way intervene with the necessity to, or the fact that the situation in Tuam meets the criteria of manifestly inappropriate.
Okay, so that the amendment be made? Tá and
Neil.
Neil. Okay, move. It's defeated then. Thank you. So now we're on to Amendment 21, which has already been discussed, that the amendment be made. You're going to press it? Okay, that the amendment be made, yes? Tá?
Neil.
Neil, okay. It's defeated, thank you. Then we're on to Amendment 22. Already, you're going to withdraw it. Thank you, Deputy. So, Minister, we're now on to Amendment 23. Can you move the amendment?
Yeah, I so move Amendment 23.
Okay, agreed? Agreed, thank you.
Yeah.
We're on to Amendment 24, which already has been discussed with one, that the amendment be made.
Basis of the Minister's amendment earlier. So.
Okay, thank you, Deputy. So now we're on to Amendment 26. So 26 to 31 inclusive are related and will be discussed together.
They're all my ones, are they?
Deputy,
Sorry.
they're yours, yeah.
Yeah.
Deputy, they're yours, and Deputy Ward's, yeah.
Okay.
Yeah.
Okay, so yeah, the reasons are 26, 27, 28 and 29 seek to ensure that the Church of Ireland and Roman Catholic Church are included as information sources, given the central role that they played in mother and baby institutions. And then in relation to Amendment 30, this amendment seeks to include any possible person that was involved in the removal of remains, reburial or burial, or any other such duties, as a great many of the records required by the Director are held by religious orders operating as charities within and without the state, within the state and then obviously outside the state too. This amendment seeks to expand the categories in which the various data controllers of churches, charities, benevolent groups, etc. fall. And I think they're my only amendments. I think 31 is the Minister's amendment. So yeah, thanks, Jeff.
Okay,
Chair.
so Deputy, Amendment 26, that the amendment be made.
I think the Minister...
Oh, Minister, you come back on that,
Yeah.
sorry, Minister.
Yeah.
I'm leaving you out, Minister.
Not at all, not at all. I think 31 is in that grouping.
Yeah, it is.
Yeah,
26
that's great.
31, sorry, Minister, yeah.
I'm hoping, so we had a discussion about this. I was under the I made the argument at committee stage that the issues that you're seeking to include explicitly were already included. But look, we've gone back to OPC and we're bringing forward an amendment which I think is quite similar to the amendment you're bringing forward. So Amendment 31 expands the list of information sources to explicitly refer to religious organisations and communities, including but not limited to a diocese or parish of the Roman Catholic Church and the Church of Ireland. I'd like to highlight the importance of future-proofing this legislation legislation, which is why I do not want to limit the reference to the Catholic Church and Church of Ireland. So I think this probably addresses, hopefully, and maybe even goes a little beyond what the deputies, what Deputy Funchion and Ward had proposed earlier on.
Thank you. Deputy, do you want to come back in, or are you?
No, just to say, probably if we discuss 31 first, we wouldn't have to discuss the others. So, no,
Okay.
I'm happy to, I'll withdraw them as we go through them, so that's fine.
Okay,
Thanks.
so Deputy Funchion then, Amendment 26, that the amendment be made, or
I'm going to withdraw 26, 27, 28 and 29.
26, 27, 28 and 29. Okay, thank you, Deputy. So we're now on to Amendment 30, and already discussed with 26. So again,
That's withdrawn as well.
that's
Sorry,
withdrawn.
no, Chair.
Yeah, okay, not at all. Thank you, Deputy. So now, Minister,
I move 31.
are you moving 31?
Yeah.
Yeah, okay. Yeah,
Agreed.
Okay, agreed. So now we have Amendment 32, arises out of the committee proceedings. So that, again, Deputy Funchion 32 is Deputy Funchion and Deputy Ward. Yeah.
So I move this amendment, Chair, and very briefly, it's basically after agency to insert and Adoption Authority of Ireland, and the reason is the Adoption Authority of Ireland also holds significant records and should be included in the remit of this bill along with TUSLA. Thank you, Chair.
Minister.
Thanks. And I did discuss that with Deputy Ward during committee stage. So section 29 that is proposed to be amended here relates solely to the database and the related records that were compiled by the Mother and Baby Home Commission of Investigation. We passed legislation about that in October 2022, and that legislation provided a copy of that database to TUSLA. But the Adoption Authority of Ireland do not have a copy of that. We specifically just said TUSLA. Yeah. So I'd argue that this is of no purpose.
Okay, so Deputy, we're on.
I'm happy to withdraw that.
You withdraw that
Yeah.
then? Okay. Thank you, Deputy. So we're now on Amendment 33, and Minister, are you moving the Amendment 33?
33.
It already has been discussed before, so the amendment being
With,
made, that's
grouping
33, yeah.
Yes, I so move, yeah.
Yeah, okay, okay. Again, Minister, Amendment 34, already discussed with 4, again, are you, yeah, again?
I move.
Yeah, okay, you move. Minister, Amendment 35, already discussed with 4, that the amendment be moved.
I move.
Again, Minister, 36, already discussed with 4, that the amendment be moved.
I move. Agreed, I think.
Agreed?
Yeah.
Yeah, agreed. Okay. Minister, Amendment 37, already discussed with 4, that the amendment be agreed.
Moved and agreed.
Moved and agreed, yeah, okay. Minister, 38, again, already discussed with 4, that the amendment be moved and agreed.
Moved and agreed.
Okay, thank you, Deputy. Amendment 39, already discussed with 4, that the amendment be made.
I move the amendment. And
Agreed.
And agreed?
Yeah.
Okay, so now we're on Amendment 40, and rising out of, again, the committee, so we'll have 40 and 41 are related and will be discussed together. Again, Deputy Funchion.
Chair, so I move Amendment 40. The reason for this amendment is there should be more emphasis in the bill on an integrated identification approach involving a multidisciplinary response. For example, there is no mention of forensic anthropology in the bill. Forensic anthropologists will be essential in the analysis of the human remains and in coordination with forensic geneticists to reassociate the human remains recovered. The absence of clearly stating their role in the process risks having unqualified and inexperienced professionals carrying out the work. Working with commingled remains is highly complex and will require experts with sufficient experience to carry out the work. And in relation to 41, it's in page 34 between lines 13 and 14 to insert the following: in accordance with the Coroners Act 1962, it's important that any excavation, recovery and post-recovery analysis of human remains is in line with that Act. Thank you, Chair.
Minister.
Thanks. Again, I think these are amendments we discussed at committee stage, and again, I'm not in a position to accept them. In relation to Amendment 40, following the PLS, I significantly revised the part of the legislation that deals with excavations, which included the addition of provisions that specify that appropriately qualified persons will undertake excavation and post-recovery analysis in line with international standards and in accordance with professional rules and guidelines. It's clear that the work needs input from a range of disciplines. Only a multidisciplinary approach can meet international standards and deliver specifically on the government's commitment in relation to the Tuam site. In relation to Amendment 41, it's not clear why excavation and post-recovery analysis under this legislation needs to be implemented in accordance with the Coroner's Act, given that the Coroner's Act does not regulate excavation. The bill does provide that if evidence of violent and unnatural death emerges, the coroner is notified. And I would again highlight the definition at the start of the bill, which specifies that forensic excavation and recovery means excavation and recovery in a manner sufficient to satisfy legal requirements regarding the use and storage of evidence in connection with the identification of remains, including in criminal proceedings. It's clear, therefore, that the legislation explicitly commits to applying forensic standards to ensure that any evidence gathered through the process can be used in proceedings, including criminal ones. And this places a clear obligation on the Director to apply forensic standards when arranging for excavations and recovery of remains under Section 35.
Thank you.
I'm going to press Amendment 40.
Okay, so President Minister Tá, yeah.
Neil.
Neil. It's carried. Now we're on to amendment.
I think it might be a bit full.
We have to. Sorry, now. That's lost. Or lost.
Yeah.
I meant to say.
Okay.
Apologies, lost. Yeah, sorry. I'm learning this. This is a new one for me. It's lost. Apologies. So now we're on to Amendment 41. Now, it was already deputy discussed with 40 that the amendment be made.
I'm going to withdraw 41.
You're withdrawing it.
Yeah.
Okay. Now, sorry, now I'm just... so now, Minister, we're on to Amendment 42, already discussed with 1, that the amendment be made.
I move the amendment.
Agreed?
Sorry, has this been, yeah, it's been discussed.
Yeah, it has been discussed with, with 1, sorry, yeah. Agreed? Yeah.
Agreed.
Okay. Minister, Amendment 43, already discussed with 1, that the amendment be made.
I move the amendment.
Move. Yeah, agreed. Okay. Again, Minister, Amendment 44, already discussed with 1, that the amendment be made.
I move the amendment.
Move. Agreed.
Agreed.
Okay. And now we're on to Amendment 45, already discussed with 6, that the amendment be made, Deputy.
I'm going to press that amendment and move. Yeah.
Okay, and Minister, Amendment 45.
45.
You've already discussed this.
You've already
We
discussed
discussed
it
it,
there,
yeah.
so...
Yeah.
Okay, you've... Tá?
Neil.
Okay, so it's lost. Yeah, okay, thank you. Oh, Amendment 46, Minister, already discussed with 5, that the amendment be made.
I move the amendment and
Agreed.
agreed.
Agreed. Okay, thank you. Amendment 47, Minister, already discussed with 3.
I move the amendment.
Agreed.
Agreed. Okay. Amendment 48, so it's out of order, Deputy.
Okay.
Thank you very much. Okay. So we're on to Amendment 49, Minister, and this is 49 to 53 inclusive are related. 52 is the physical yet. So and 49 is inclusive. Will be discussed together. So we have 49 to 53. Minister, and that's Amendment 49.
Yeah, I move Amendment 49, Chair. Amendment 52, which was also put forward by Deputies Funchion and Ward at committee stage, seeks to expand the definition of relevant information to be used by a director in establishing a familial link in an identification programme. At committee stage, I explained that the intention had always been to facilitate the use of different types of documentation, and in this regard, the definition of relevant information in the bill is open-ended and provides only brief examples. However, I committed to examining how the definition could be expanded in terms of more explicit and wide-ranging examples. Amendments 49, 50, 51 and 53 provide for the broadening of the text of the definition of relevant information with due regard to the amendments put forward by the Deputy authorities. The bill continues to provide for an open-ended definition, but expands on the examples given to include baptismal certificates, institutional admission and discharge records and information obtained in post-recovery analysis. I hope this addresses the Deputy's concerns in relation to this.
Okay.
Can I come in on this? Yeah, I'm glad actually to see this being included, and I think it'll negate our Amendment 52. I think we can probably withdraw that on this basis. So I welcome that, that's been included in it. Thanks.
Thank you, Deputy. So, Minister, that the Amendment 49 be made?
Agreed.
Agreed. Deputy?
Agreed, yeah. Sorry.
Agreed. Okay, thank you. Then Amendment 50, already discussed with 49, that the amendment be made?
I move it and...
Agreed.
Agreed. Okay, it's lost. Okay.
It's carried, I think.
Carried,
it's agreed.
carried.
Yeah.
Oh
Yeah.
gosh, I tell you, I'm getting used to it. It's carried, yes. Amendment 51, already discussed with 49, that the amendment be made?
I move
Agreed.
the amendment.
Agreed.
Agreed.
Perfect. So that's carried. So now we have Amendment 52, already discussed with 49, that the amendment be made.
I'm going to withdraw,
Withdraw, okay.
52 on the basis of Minister's 51.
Okay, thank you very much. So Amendment 53, Minister, already discussed with 49, that the amendment be made.
I move the amendment and it's agreed.
Agreed.
Okay. Amendment 54, Minister, already discussed with 3, that the amendment be made.
Agreed.
Agreed.
Agreed. Okay. Then we're on to Amendment 55, already discussed with 4, that the amendment be made.
Agreed.
Agreed. Minister, Amendment 56, already discussed with 4, that the amendment be made.
I move the amendment and agreed.
Agreed. Okay. So Amendment 57, 57 to 61 inclusive are related and will be discussed together again, Minister.
Thanks, Chair. So I signal my intention at committee stage to bring forward amendments to sections 67 and 69 in relation to the process of deleting information associated with an identification programme. These technical amendments are being proposed on foot of advice we received from Forensic Science Ireland. Amendment 57 provides that certain information can be retained by FSI to show how the process of samples and profiles has complied with the provision of the legislation. This amendment aligns the approach taken to the deletion of related information in situations where samples are destroyed and profiles are deleted with that is in place under the Criminal Justice Forensic Evidence and DNA Database System Act of 2014, which FSI has advised has worked well. Amendments 58 to 61 will facilitate a more direct way of linking a second or subsequent bone from a deceased person to a family member. The amendment authorises the retention of DNA profiles from relevant persons after there has been a notification of a familial link, so that any further remains from a deceased person who has already been linked to a family member can be more easily linked to that person again. This is important in a site like Tuam, where individualising remains may be challenging, and it is possible that more than one bone from the same person will be sent for analysis. The amendments will enable FSI to use the most direct way of comparing the DNA profile of such bones with the DNA profile of family members.
Minister, can you just go through which amendments they were? Because they're not actually in the copy of these amendments. And maybe I just don't have the most updated. It's 57, 58?
So it's 57, 58, 59, 60 and 61.
Yeah. Okay, they're actually not in the report amendments in this list, just for people's information. Now, I know from what you're saying and from what you've said in the past that we'd be accepting the amendments, but just so I suppose from a procedural point of view, we don't actually have a copy of the wording in front of us, but we would be agreeable to them anyway. Do you have them? Okay. So just, I'm not opposing the amendments, but just to say that we don't actually have a copy of the wording of them.
Okay.
Yeah.
Thank you, Deputy. So Amendment 57, that Amendment 57 be made.
Agreed.
Agreed. Okay. Amendment 58, already discussed with 57, that the amendment be made.
I move it, I think, first.
You want to move it?
I think I have to move each one, don't I?
Do you have to move it? Okay,
Yeah,
so you move that, Minister, okay. Sorry now. Minister, so you move that, okay. Thank you. So that the amendment be made?
Agreed.
Agreed. So, Minister, that you move the amendment and that the amendment be made?
Move 59, yeah.
Move 59, yeah. Minister, that
Agreed.
agreed?
Yeah.
So, Minister, that you move 60,
Move
Amendment
60.
60, and that the amendment be made.
Agreed.
Minister, that you move 61 amendment.
I move.
Already discussed, and you, yeah, perfect.
Agreed.
Minister, that you
Agreed.
move Amendment 62, already discussed before, and that the amendment be made.
That is, yeah, I move.
Agreed.
And agreed. Okay. So we're on to 63, and Minister, again, that you move that because it's already discussed before, and that the amendment be made.
I move.
Okay.
Agreed.
Okay. Minister, that you move Amendment 64,
I move.
already discussed before, that the amendment be made.
Agreed.
Okay, thank you. Minister, Amendment 65. So 65 and 66 are related and will be discussed together.
Thanks, Chair. Amendments 65 and 66 are technical amendments that clarify that an appeal against the determination of the Director in relation to participation in an identification programme or a finding that the genetic and non-genetic data are not sufficient to suggest the familial link must be made within an 8-week period. Originally it had been made within an 8-week period, but I think important in terms of an appeal being made, there has to be a clear timeline within which that appeal will be made. So it's on that basis that we're making this amendment.
Okay, thank you, Deputy. Would you like to?
Yep.
Okay. So, Minister, Amendment 65, that you move Amendment 65, that
I
the
move.
amendment be made?
Agreed.
Agreed. Okay, yeah. Amendment 66, Minister, that you move the amendment and that the amendment be made?
I move the amendment.
Agreed.
Already
Agreed.
discussed, yeah. Okay, Amendment 67, Minister, that you move the amendment. So it's 67 to 71 inclusive are related and will be discussed together. Minister, thank you.
Thanks, Chair. I move 67 and I'll discuss that grouping together. I signalled my attention at committee stage to bring forward amendments at report stage related to compensation in the context of assessing land. Due to reconfigurations and amendments made to Part 5 of the bill, there is currently no provision for statement of compensation or notification of when works will commence to issue to public bodies where they are the owner or occupier of land. Amendment 67 to 70 seek to address this. Amendment 71 clarifies that the period of time for the calculation of the compensation is the period during which it is estimated that relevant works or related activities will be carried out, and not the period specified in an order under section 82.2 or 84.2. The amendment is necessary because a statement of compensation will have issued before an order could be made under section 82.2 or 84.2.
Can I just want to come in on those briefly, just to welcome them, and I think that they're good additions to the legislation, and I think, in fairness, a lot of the, I suppose, discussions and topics that we discussed at the committee stage and at PLS stage have been taken on board, and I think that's really welcome. So I just wanted to welcome those. Thanks, Minister.
You're okay then, Deputy? Yeah. Okay.
Yep.
So, Minister, Amendment 65, that you move Amendment 65, the amendment be made?
Are we on 67 there?
You're gone to 67, are you? Okay, perfect. You're ahead of me. I've gone back. Okay, so Minister, that you move,
move
Amendment 67,
Agreed.
and that the amendment be made?
Agreed.
Agreed. Okay. Minister, that you move Amendment 68?
Move.
Already discussed, so you agree? Okay.
Agreed.
Agreed. Okay, I'm only learning all these amendments now. So, Minister, that you move Amendment 69, already discussed, and the amendment be made?
I move the amendment.
Agreed. Agreed. Minister, that you move Amendment 70, already discussed, and that the amendment be made?
I move the amendment.
Agreed.
Agreed.
Okay. Minister, that you move Amendment 71, already discussed, and that the amendment be made?
I move the amendment.
Agreed.
Agreed. Okay. Minister, that you move Amendment 72, rise out of the committee. So it's 72 to 75 inclusive and are related and will be discussed together. Sorry.
I move 72, Chair. At committee stage, I signalled my intention to bring forward an amendment at report stage to remove the provision exempting the Director from carrying out remedial works on a site where the owner or occupier plan to carry out the works themselves or where the land is subject to development. The amendment is on foot of engagement with the Department of Housing, Local Government and Heritage, who advised that it would be appropriate for the Director to remediate the site in circumstances where intervention at a site is exempt from planning permission.
Thank you, Deputy. You're okay? Okay, so Minister, I ask that you move 72 and that the amendment be made.
Move
Move.
72. Agreed.
Minister, Amendment 73, I ask you that you move Amendment 73, already discussed, and that the amendment be made.
I move the amendment.
Agreed. Minister, Amendment 74, I ask that you move that amendment that has already been discussed, that the amendment be made.
Move the amendment. Agreed.
Okay, so we're agreed?
Yep, agreed.
We're on Amendments 75, already discussed with 72, that the amendment be made. So I ask you that you move the amendment, Minister.
I move the amendment.
Okay. Agreed? Yeah. Minister, we're on Amendment 76, that you move the, that you move the amendments, but it's 76 to 79 inclusive and are related and will be discussed together.
Yeah, I move 76, Chair. So, look, 76, 77, 78 are my own, and 79 is an amendment from Deputy Funchion and Ward. And this was something we discussed in some detail at committee stage, and deputies raised the concern that in order for as we know, there will be a report coming from an agency set up under this legislation, and the report will be published, but deputies wanted to ensure that the director of the agency would be able to come before a joint Oireachtas committee to discuss the report, and in particular that the dissolution of the agency that coincides with the production of the report wouldn't mean that there was now no director to come before the joint Oireachtas committee. So it was a measure to enhance accountability. So we did engage with the Office of Parliamentary Counsel, and we've brought forward a mechanism that we believe addresses this. So amendments 77 and 78 are aimed at addressing the deputy's concerns by providing that a director will be required to submit a final report to the relevant minister at least 12 weeks before the day in which the agency is dissolved. And the relevant minister will then be required to lay the report within 6 weeks of receipt, so lay it before the Dáil. This timeline would provide for, at a minimum, a guaranteed 6-week window when a director could be called before an Oireachtas committee to discuss the report prior to dissolution day. And 76 is consequential amendment, which provides that the relevant minister must notify a director at least 6 months in advance of the day proposed to be dissolution day. And this ensures that the director is given sufficient notice to prepare the final report, and I hope this addresses the issues that have been raised by deputies.
Thank you.
Thanks, Cathleen, and thanks, Minister. Yeah, I'm going to withdraw our 79, but I do want to just come in on this group of amendments, first of all, to welcome them and to say that I think probably everybody was basing this on, I suppose, in the aftermath of the publication of the Mother and Baby report, and the fact that there was, I suppose, a frustration or an anger felt that, you know, there was no accountability there. And I know as a committee we did write, I think it was on 3 occasions, or at least, to inviting them in, and they refused. So we thought that this was an important provision to have in, and I think that it has been dealt with, and we welcome that. I'm glad that you took it on board. Thanks.
Deputy. Deputy Cannon, yeah. You want to?
Thank you for including this. The accountability and the timelines are very important, and all of this work, and I think it's important, and thank you for taking it on board.
Thank you,
Agree with it.
Deputy. Thank you. So Amendment 76, then you've moved it so that the amendment be made.
Agreed.
Amendment 77, already discussed with 76, that you move the amendment, Minister.
I move it.
Move it.
Agreed.
Agreed. Amendment 78, already discussed, that you move Amendment 78, Minister.
I move it.
Move it. And Amendment 79, Deputy Funchion, you're withdrawing that. Okay. So I think I just want to thank you, Minister, and thank you, Deputy, now. And so we now proceed. Where do you want to go? Sorry, we're just taking a minute here. So we now proceed to 5th stage. So I ask the Minister to move.
I so move.
Okay. That the bill do now pass.
Agreed.
Agreed? Okay.
That's it.
That's it. Is that it? Thank you. It's my first time to do amendments, so thank you very much.
Thanks, Chair. Thanks very much.
Thank you.
Appreciate it.